The Honorable Judge Simpson.
You may be seated. Court does call the cases. The People versus Lori Anderson.
Ashley Long for the people. Good morning.
Good morning.
Good morning, Your Honor. Hugo J. McIntyre on behalf of Ms. Anderson, who is in the courtroom this morning.
All right. Very good. Thank you.
And the defendant is ready to proceed, Your Honor.
All right.
See.
We're ready as well, Your Honor.
All right. Very good.
Your Honor, I only have one witness. I understand defense may have more than one witness, and I would like sequestration.
All right.
No objection, Your Honor.
All right. Witnesses are hereby ordered sequestered. They must remain in the hallway. They are not to discuss their testimony until this matter has concluded.
Nor watch on YouTube, Your Honor.
Before this case even gets underway, Judge Simpson is already setting the tone. Witnesses are being sequestered, instructions are crystal clear, and the courtroom is preparing for a credibility battle. What looks like a simple dispute between a landlord and tenant is about to evolve into something far more complicated. The prosecution appears ready to frame this as an unwanted physical encounter. The defense, meanwhile, is already hinting that key context may be missing. Questions about absent witnesses are surfacing before testimony has even begun. That alone tells you both sides understand how much this case may depend on interpretation rather than indisputable evidence. Was this a criminal act? A landlord-tenant dispute that spiraled out of control? Or a collision of conflicting accounts where credibility becomes everything? Stay with us, because every detail from this point forward will matter.
Or watch on you.
Thank you, Your Honor.
Yes, Your Honor, there is one other matter I want to bring to the court's attention. One of the witnesses that we had subpoenaed today was Officer Olivia Boatwright from the Pittsfield Township Police Department.
Yes.
Subpoena was sent to her on June the 7th.
Okay.
And I've been in contact with her command officer, and she is on vacation. So we emailed it and we sent it to the police department. So I'm not quite sure what happened, but I don't know Officer Boatwright, but I hear she's very reliable and trustworthy. So something has happened.
But she's on vacation at this time?
Yes,
you're informed she is.
Yes. But she is not an officer that was directly involved in reporting this situation. She's an officer that my client spoke to later on relative to the situation. I would develop that once the trial starts. So she is not, I don't want to say not relevant, but not relevant.
Okay. So you don't know whether, I mean, obviously you subpoenaed her. Is her testimony then crucial to your defense of this case, or?
It is tangential, Your Honor. It is tangential.
Okay. So I guess when we get to that, we'll deal with it.
All right, Your
I
Honor.
guess it's probably the best way I can. All right, let you make an assessment as to whether or not you would need her testimony or want it. Ms. Lundy.
And that is what Mr. Mack and I discussed as well. I let him know that I didn't anticipate that I'd have much for Officer Boatwright, if anything. So it would really be his witness. And if he felt he needed her to do the trial, that I was flexible with that. I understood he may need her.
Okay. All right. Thank you. Have the witnesses been adequately sequestered?
Yes, sir. My sole witness is still in the courtroom,
Okay.
with his support person.
Got it. Okay. Then you may proceed.
Thank you, Your Honor. With defense's consent, I will waive opening.
Any objection, Mr. Mack, to?
No objection, Your Honor.
All right. Would you like to give an opening now, or would you like to reserve or waive your opening?
Your Honor, I would like to reserve our opening.
All right. Very good. Thank you. You may call your first witness.
Marcos Lascanos.
Please come forward and be sworn.
Please sit down, raise your hand. Swear affirm the testimony you're about to give will be the truth, no truth, and nothing but the truth, as we have. Go ahead, have a seat, and then state and spell your name.
My name is Marcos Lascano. It's Marcos, last name Lascano, Lascano.
All right. You may inquire.
Sir, are you familiar with the address of 4259 Shandy Court?
There.
Sorry?
Yes, sorry. I just didn't live there long, so it's hard to remember.
That's a place you lived? Is that a yes?
Yes.
So we're making an audio recording of all of our proceedings today. And when we have the mms and the things, they don't show up great on the recording. So if I ask you for clarification, please don't be offended. It's just for the record. That 4259 Shandy Court, what township is that in?
Ypsilanti.
That's in Ypsilanti. Do you know if it's in Pittsfield Township, Ann Arbor Township? Do you recall?
No.
Do you know that it's in Washtenaw County?
Yeah.
Okay. And do you know it's in the state of Michigan?
Yes.
Your Honor, I ask the court to take judicial notice that 4529 Shandy Court, Ypsilanti 48197 is in Pittsfield Township.
Without objection, the court will take judicial notice that that is located in Pittsfield Township.
Thank you, Your Honor.
This may sound like a minor detail, but jurisdiction matters. Before a court can decide what happened, it has to establish where it happened. By taking judicial notice of the property's location, Judge Simpson eliminates unnecessary disputes over geography and keeps everyone focused on the substantive issues. From a storytelling perspective, this is where the house itself starts becoming a character in the case. We're learning who lived there, how many people occupied the property, and the relationships between landlord and tenants. These details may later influence perceptions about shared spaces, expectations, and authority within the home. The witness is also presenting as somewhat uncertain on certain specifics, which both sides may exploit differently. The prosecution may argue he's being honest about what he doesn't remember. The defense may argue those gaps undermine reliability. Either way, credibility is quietly moving towards center stage.
You said you lived at that address, sir?
Yes.
When did you live there?
For about 2 months, November and September, I believe.
What year?
2024.
Did you live there with anyone else?
I lived there with a few other people. I remember, I lived there with Lori and his son. I don't remember his name. I remember I lived there with another roommate named Paul. And then I lived there with another roommate. Forgetting his name as well. And then I lived there with another roommate. That was only for a week. It was just a lot of people shifting in and out of this house.
Did you mention the name Lori Anderson? Who was that?
That was my,
Your tenant?
yes, the person who owned the house that I stayed at. And I rented a room out of that house.
So the person that owned the property where you were living, you called that person a tenant. Have you ever heard that person called a landlord before?
Yeah, sorry, landlord.
Do you see the person you know to be Lori Anderson in the courtroom today?
Yes.
Can you please identify her by an article of clothing that she's wearing and where she's sitting?
It looks like she's wearing.
And where is she sitting?
She's sitting next to lawyer, wearing the blue suit coat.
Your Honor, may the record reflect the witness identify the defendant?
Without objection, record shall so reflect.
Do you recall having contact with Miss Anderson on November the 16th, 2024 at that address on Shandy in Pittsfield Township?
Yeah.
How did you first have contact with her on that day at that address?
We usually didn't really talk much. It was mostly just brief, curt, like saying hi, hello, not much. So I don't remember much from that day. If we did communicate first throughout that day, it must have been that. But the first solid interaction I remember throughout the day, must have been through that text that I sent. The text to everyone who lived in that house, which included her, which was just me saying that I needed to get my laundry done.
And did she live there?
No.
Would she stay there?
She spent multiple days there, spending the nights there.
How do you know she would spend the nights there?
Because she keep her car there, and she would sleep there in the spare room with her dog, and her dog would bark a lot, so that was also a lot of her.
This property, can you describe kind of how it is set up, what it is? Is it like an apartment building or something else?
Regular type home. You have probably 1, 2, 3, 4 bedrooms upstairs. One of them was the office, but she just mostly stayed Don't know what it looked like on the inside, maybe it was the couch. Sleep on better. It was the son's room, my room, it was my roommate's room, hall, and then it also had the laundry room and a bathroom. And downstairs were the kitchen and the basement, which Lori had eventually converted into another bedroom. Well, another room.
Can I have permission to approach the witness with what's been marked as People's Proposed Exhibit 1?
No objection, no.
All right, yes.
I've shown it to defense counsel. Sir, I've placed in front of you what's been marked People's Proposed Exhibit 1. What do you recognize that to be?
Looks like the second lease that we signed.
The lease agreement has officially entered the courtroom, and documents like these can dramatically shift a case. Why? Because written agreements establish expectations. Quiet hours, shared facilities, and responsibilities aren't just casual understandings anymore. They're potentially enforceable rules governing daily life within the home. The defense will almost certainly use this lease to argue that the defendant was attempting to uphold agreed-upon standards. The prosecution, on the other hand, may argue that regardless of house rules, certain conduct crosses legal boundaries. This is where civil obligations and criminal allegations begin intersecting in complicated ways. A lease can explain why someone acted, but it doesn't automatically justify how they acted. That's a distinction Judge Simpson will ultimately have to evaluate. The courtroom is gradually transitioning from background information into the events of the night itself, and tensions are beginning to rise.
And is this the one that was applicable at the time of this incident, November the 16th, 2024?
Yes.
Have you had a chance to review that earlier this morning? Is that a yes?
Yes, sorry.
Is this a fair and accurate copy of your lease?
Yes.
Move for the admission of 1.
Any objection or voir dire?
No objection, no.
All right, Exhibit 1 is admitted.
Permission to publish to the court?
Yes.
Can you go ahead and pass that up to Judge Simpson? He's going to take a look at that.
Thank you, sir.
So on November 16, 2024, after you had texted the group chat about needing to get your laundry done, did you ever see Miss Anderson?
No, all I kept hearing was the laundry machine going off.
Okay, so what laundry machines were there in this house that you recall?
There was 2 laundry machines. It was the washer and the dryer in the laundry room.
What time do you remember doing your laundry?
I must just try starting around 9 o'clock, 10 o'clock.
9 or 10 o'clock at night? All right.
Yeah, I wasn't able to do my laundry throughout the whole day because the son had kept his laundry in the laundry machine all day.
When you say the son, whose son is that?
Lord's son.
Now, as you heard your laundry machines going off, what did you do?
I was hanging out in my bed waiting because I needed to do my laundry for work tomorrow. I kept hearing them go off. It wasn't like immediate, like, oh, stop. It was like, oh, they're not going on anymore. So I get up, go in, turn them back on, and then I'd go and text and I'd say, can't I probably go back to my text, look at them. What I said was, hey, I need to do my laundry for work tomorrow. There was laundry stuck in here all day. It needs to get done.
Were the laundry facilities shared from everybody in the house?
Yeah.
When you went back in to check on your laundry, did you ever see anyone else in that room?
No, it seems like whoever was turning out, whether it was their son or Lori, it seemed they kept doing it as soon as I left. I turned it out and turned it back on.
At some time later that evening, did you ever see anyone else in that room?
It was only after maybe the 3rd or 2nd time that I had turned it back on. I eventually just stayed in that room because I felt like I had to guard my laundry.
What happened next?
What happened after that was eventually Lori had come in and saying that it was too loud and we don't do laundry after this time. And that it was time, we're not doing this anymore. She turned it off. And things just started escalating from there. I tried explaining that laundry stuck in the machine all day and that I had to do my laundry for work tomorrow.
At any time, did she ever start handling your clothes?
Yes.
What happened?
That's when I brought up my phone and started recording. That's when I started telling her, this is my property, these are my clothes, you're not allowed to be touching my stuff.
What happened after you started recording?
She just kept going. It didn't matter. She just started just doing what she was doing. She didn't care about anything. She just said, I started to get out of her house, that I'm done, that it doesn't matter. And then just things started escalating. She started grabbing my stuff. And then someone would get or turning off the light.
Okay, let's slow down. It's okay. Let's just slow down, take it one question at a time. So when you said you started recording, is that right? Is that a yes?
Yes.
Have you had a chance to review that one of your recordings this morning?
Yes.
And was it a fair and accurate copy of the recording that you
Yeah.
made that day? Okay. Your Honor, I'm gonna move for the admission of Peoples 2, which is video titled IMG, and that's India Mango Golf 4676. This has been disclosed in discovery.
All right, you may go ahead.
Thank you.
We're now entering one of the most critical phases of the trial, video evidence. Jurors and judges often place enormous weight on recordings because they appear objective, but appearances can be deceiving. Videos capture angles, sounds, and fragments of events, not necessarily the entire story. Both sides know this. The prosecution will likely emphasize what the footage shows directly. The defense may focus just as heavily on what it does not show. That's why context matters. Who started the confrontation? What happened before recording began? What happened immediately afterward? These unanswered questions frequently become battlegrounds in court. As this footage unfolds, pay attention not only to what's visible, but also to the interpretations each side attaches to it. Do you think video evidence always tells the whole truth? Or can perspective completely change its meaning? That's exactly the issue Judge Simpson is about to confront.
You're not gonna touch my property. No. You can't touch my property. It's not acceptable. Can you please not touch me? Can you please stop touching me? Can you please stop touching me? No, I can't live here. What the hell? No, you can't do that. How can you do that? Have you sent me a breach notice?
You're out on the set.
No, you can't do that. You know you can't do that. You have no legal right to do that. If you want to try doing that, let's go to court. Please stop touching me. Please stop. You're grabbing your hand now. Okay. She's not grabbing me. Look, I'm gonna keep this light on. Okay.
Mr. Loscano, what happened after the end of People's Exhibit 2, that video? Maybe, may I rephrase, Your Honor? Excuse me.
Yeah.
Mr. Loscano, what happened as that video was ending?
Her son started getting involved.
And did anyone touch you? Who is that a yes?
Yes, sorry. I know two people entered the room, and I know that it was dark. I know my phone was taken away from me. That's why I stopped recording, and I know I got pushed up against the wall.
And who was the person that pushed you up against the wall? You don't know?
I know that as soon as I started feeling threatened, the lights were up, and I felt myself push against the wall. That's when I said, I had a pepper spray in my pocket. You go back off with me. I'm going to that myself. It felt like it was one person. I don't know. That's when the son stepped in as well, but yeah, that's,
Mr. Loscano, did you consent to Miss Anderson grabbing your fingers on the light switch and touching you in that way?
you know,
Did you give her permission to do that? At any time during this evening, did you grab her breast?
no,
Did you at any time grab anywhere else on her body?
no.
What happened after this all happened in the laundry room?
After I told them I had pepper spray, they, whoever was pushing me against the wall backed off. And the son threatened to then kick my ass if I did anything.
Threat allegations significantly raise the stakes. Physical contact alone can be interpreted in various ways depending on context, but introducing alleged threats adds another layer of seriousness. Notice, however, that the witness also acknowledges uncertainty regarding who specifically pushed him. Those details matter tremendously because criminal responsibility must be established with precision. The prosecution may argue that the totality of circumstances supports the complainant's account. The defense will undoubtedly highlight every inconsistency and every point of uncertainty. This is where credibility becomes paramount. Judges frequently assess not just what witnesses say, but how they say it, whether they acknowledge limitations in memory, and whether their narratives remain consistent over time. The courtroom is no longer discussing laundry schedules. It is now wrestling with competing descriptions of fear, intent, and accountability.
And then that's when I called my roommate Paul for help.
Did Paul contact the police or did you?
I don't know.
Okay. May I have one moment, Your Honor? It's okay.
I think I might have made a note because I believe he didn't want to get 911 involved. He was too scared about escalating. If I remember
Give me just 1 second, sir.
John, I'm sorry. He said something about he was too, I didn't hear what.
Scared?
I object to that being admitted, Your Honor, as characterization as to what somebody else was feeling. Or matter of fact, where is Paul? Paul can testify for himself. Is he here?
Well, I understand that. I don't know that that has much bearing for the court. I mean, the question was who called 911. So I'll overrule your objection, but I can't see it having any consideration for the court.
Your Honor, I understand.
Pass the witness.
All right, cross-examination.
Your Honor, I confess to not being a slave to technology. I ask the court's indulgence.
We are well aware, Mr.
Well, thank you, Judge.
We will do what we can to assist you through that part.
Okay.
You're gonna play something.
Yes, actually.
Oh. All right. I was gonna say you broke it. Just to scare him.
And then once you plug into here, you should be good.
Oh, yeah, I'm plugged in.
See, this is why I count on my public servant for help. No, seriously.
It's okay. I charge for her service. We'll send you the bill, Mr.
Okay.
Are you going to be seeking the admission of this or is this the same video?
Judge, this is the this is the same video. Oh, excuse me. I'm sorry. That's another case. Sorry. Apologize. This is the same video, and I apologize to the court.
No, it's okay. It's okay.
I don't understand how.
I just want to make. It's the same video as Exhibit 2.
It is.
All right.
It is. The,
Oh, no, you're touching my clothes now. That's not okay. You can't touch my property. You're not allowed to touch my property. So.
it's not on the screen.
Oh, there we go. Okay, now we got it.
Hello, thanks, Lee.
So I'm going to stop the video right there. Is that your voice on the video? And isn't it true that that is your phone that you're making the video with? Is that true?
Yes.
Now, the state had previously admitted People's Exhibit 1. We have the exact same lease. I can ask for it to be marked, Your Honor, if it's necessary.
The exact same?
Exactly.
You're gonna question him on this?
Yes.
Okay, I'll just hand that back to you,
So,
sir.
Cross-examination has shifted into full gear, and the defense strategy is becoming increasingly apparent. Instead of focusing exclusively on the alleged touching, attention is being redirected toward quiet hours, timing, available alternatives, and the complainant's own decisions throughout the evening. This approach isn't unusual. Defense attorneys often attempt to broaden the lens, encouraging the court to consider whether the situation arose from poor choices and escalating tensions rather than criminal intent. Meanwhile, the prosecution will work to keep the spotlight firmly fixed on the conduct they believe violated the law. Judge Simpson continues serving as gatekeeper, allowing relevant questioning while maintaining procedural order. These exchanges may seem repetitive, but repetition is often deliberate. Attorneys revisit details because inconsistencies or confirmations can emerge through persistence. The battle over narrative control is officially underway.
I don't know if the necessity of me admitting this, unless the court feels I need to. It's the same exhibit.
Same, no, that's fine. If you're gonna, you can question him on Exhibit 1 then.
Okay. Now, that is your signature at the bottom, correct, sir?
Yes.
Now, and look, in terms of house rules, doesn't it say must maintain quiet hours after 9 p.m.? And when you say that some laundry was in the laundry room 9 or 10, you didn't call the police till well after 12 midnight the next day, sir.
Objection is to form.
Yes. Is that a question?
Well, isn't it true you didn't call the police till well after midnight?
Not sure what exact time I called the police. I don't know what time this was called.
Well, do you remember talking to the police outside on the front porch that morning, sir?
I remember.
Okay. So is it your statement to this court that you don't know if it was well after midnight when you called the police?
The police were probably called to late into the night.
Okay, I'm not talking about late into the night, I'm talking about after midnight.
Yes, they were called late at night, so I guess it was called after 9 p.m. quiet hours.
Okay, so when you tell the judge that 9 or 10, some vague time reference there, clothes were in there, this incident didn't happen at 9 or 10. This incident happened after midnight.
Check the police logs and check when the police were called after that time.
Okay. So now, isn't it true that where the laundry room is, which is where this video was taken, correct? Okay.
Yes.
The answer, yes.
Sorry.
Isn't it true there are at least 4 rooms right on that same floor where this laundry room is?
Yes.
There's your room. Yes. There was a room where the defendant was staying at, correct? Okay. There was a room where John was staying at, correct? And there's a room where Paul was staying at, correct?
Yeah.
Okay. And isn't it true that that laundry room there is within no more than 15 feet of any one of those rooms?
Yeah.
Okay, so they're right on the same floor in close proximity to each other, correct?
Yes.
And there is in fact a door on that laundry room, correct?
Yeah.
All right. So now, when you were in that laundry room, do you remember telling the police you could have gone to an all-night laundry, but you were fearful of doing so because they go through your stuff when you leave?
I remember telling the police that.
Right.
Yes.
Okay. So you knew you had an option, didn't you, sir? You knew you had an option to go to an all-night laundry instead of being in that laundry room after midnight. You knew that, didn't you?
I don't see how this pertains.
Oh, okay. Well, we have a very competent prosecuting attorney that can make those objections, but your job is to answer my questions. Got it?
Yes, but
Okay, no, sir. I asked you a yes or no question with a yes or no answer. You knew you had an option rather than excuse, sir. you had an option.
No.
You could, can I finish my question?
Sure, I can answer.
You had an, can I finish my question?
Did he answer the question? He asked if I had an option. I said
Sir,
no.
sir,
I don't have a.
sir. Yes,
Okay.
you will wait for Mr. Mack to finish his question and then answer.
Okay.
Go ahead, Mr. Mack.
You knew, as reflected by what you just stated, that you mentioned to the police, that you could have gone to an all-night laundry, but chose not to because, according to you, when you leave, they go through your stuff. Is that correct?
Yes.
Okay.
The prosecution presented this witness as someone trying to finish laundry for work the next day. The defense is now reframing him as someone who knowingly ignored alternatives. That's a major shift in narrative. If he had other options like using a laundromat, the defense wants the court to wonder why he stayed in a situation that was already escalating. But legal responsibility doesn't disappear simply because someone could have walked away. Courts often wrestle with these uncomfortable realities. Human beings don't always make the smartest decisions under stress. Poor judgment isn't necessarily criminal conduct. Judge Simpson now has to evaluate whether this witness's decisions affect his credibility or merely provide background to an encounter that ultimately crossed legal boundaries.
Now, when you say you put out a group chat, a group chat about laundry?
Yes. It's part of it. We have a group chat.
Okay, group text. Did you ever present that group text to the prosecutor? Why?
We talked about this group text a lot. Like it's this communication. It's not. It seems like I recorded. I brought it over to every single communication that was brought across. I'm glad to show it to you. It's not something I've been trying to hide.
So this group text, now in the group text, was the defendant part of the,
Yes.
okay, can I finish? Was the defendant part of the group text?
Yes.
Did the defendant give you permission to be in the laundry room after 9 p.m. in the group text?
No.
Okay. The answer to my question is yes or no.
Yes.
She did give you permission?
Previous question. Permission not. There was never permission not being people.
Well, you say there was never permission to not being there either, but there was a lease that said quiet hours after 9 p.m. Okay, correct, sir? All right.
Yeah.
Now, in terms of you being in the laundry room, even though you knew you had options, you went to that laundry room armed with mace, did you not?
Yes.
Okay, so you went to a laundry room when you knew you had options, armed with mace, correct?
Yes.
At any point in time, did the defendant ever assault you or threaten you with mace?
No.
So when the video is playing and the clothes are being taken out, the whole nub of this entire situation is she wanted to turn the light switch off for you to be out of a place you had no right to be in the first place. And you want to keep the light switch on. Isn't that just the whole sum of this whole thing?
Object is to speculation.
I'll sustain that. You'll need to
And
phrase your
comment.
question.
When you were, let's just say, finger tussling with the defendant, what was your goal, sir?
To
When you were finger tussling over a light switch to feel safe?
maintain the vision. Yes.
Okay, so to maintain, so your goal wasn't to keep the light on?
Keep the light on to maintain vision.
Okay. So, but as the means of maintaining the vision, you wanted the light switch kept on, correct? Okay. So isn't it true that when she had turned the light switch on, you turned it off, you turned it back on? I know you got to say yes. I know it's cumbersome, but you got to answer. Correct?
Yes.
And isn't it true that the only contact that you and the defendant had was in the finger dynamic over the light switch?
No, in the video, you can see her grab my arm. Pull it away.
Okay, but when you say grab your arm and pull it away, it's relative to the control of the light switch.
It's more than finger testing. She puts her hand on my arm.
Yes.
That's an increased aggression.
Okay, well, okay, like I said, that's why we have a judge. He will decide that.
Now we're getting into the heart of the dispute. How should the physical interaction itself be characterized? The witness sees escalating aggression. The defense sees mutual contact occurring during a struggle over a light switch. Those are dramatically different interpretations of the same sequence of events. This is exactly why assault and battery cases can become so difficult. Intent, perception, and context all matter. The same physical act can look entirely different depending on who is describing it. Judge Simpson isn't just evaluating facts, he's evaluating competing narratives. Which explanation aligns more closely with the evidence? Which version remains consistent under scrutiny? The answers to those questions could determine the outcome of this case.
So,
You said fingers.
Sir, he will ask a question and you'll answer. Understood?
Yeah.
All right, go ahead, Mr. Mayor.
so when the defendant moved your hand away from the light switch, you moved your hand back up to the light switch, isn't that true?
Yeah.
Why did you do that?
She put the light back on.
Why didn't you just simply leave the room?
Her son and her were standing in the doorway, and I wanted to feel safe with my back against the wall to put the light on.
Okay, now her son, you say her son were standing in the doorway, right?
In the video, I said, "Hang
Oh, okay, no. You said her son was standing in the doorway, correct?
I'm being very journalistic. I apologize, but her son was standing in the hallway. The hallway leads down like this, and not trying to come.
Well,
Like he's a pretty big dude,
Well,
6 something. It's
okay.
like, yeah, he's imposing.
well, but excuse me, sir. When you are facing going out of the washroom, okay, her son's room is to the left, your room is to the right.
Left, right. So I have to go past him, even then he's standing right there.
Okay, so,
I have to pass by him to get there, and he's standing right there.
Okay.
And these aren't my friends.
okay, so are you telling me, and we're gonna play the rest of this video, are you telling me you couldn't turn right when you got out of that door and go to your room?
I want no obstacles in my way before I went back.
Sir, I'm asking a very simple question. When you're exiting out of the washroom, okay,
Sure.
I'm asking you, isn't it true your room is to the right? You turn right to go to your room.
Not before I see both of their rooms, before both people are standing in the hallway.
Okay, sir, I'm asking you a simple matter of a structure of a house. Is it not true when you go out of the door from the washroom, your room is to the right and the son's room is to the left?
No, you're not. I can draw this out for you.
Okay. So what you're saying is you had to pass by John to get to your room, is what you're saying.
It's all the way down the hall.
Okay, so now when you talk about the grabbing of the wrist, okay, after she moved your wrist to stop you from turning the light on again, and you still try to turn the light on, correct? Wasn't there some more like finger dynamic between you and her trying to control the switch?
Yeah, after she left from, I turned the light on, she came back in to turn it on.
Okay.
She kept coming back.
Okay, yes, but she wasn't coming back to your room. She come back to a washroom, which you were wrongfully in the first place.
Both sides are painting a picture of persistence. The witness describes repeated returns to the laundry room. The defense emphasizes opportunities to disengage. The result is a scenario where neither side is portraying the incident as spontaneous. Instead, this appears to have unfolded through a series of choices made over several minutes. That's significant because courts often consider whether parties had opportunities to de-escalate. Did either person attempt to walk away? Did emotions override judgment? Did frustration cloud decision-making? These aren't merely philosophical questions. They can shape how intent and reasonableness are assessed in a legal setting.
Wrongfully in?
Yes.
Yeah, object is the characterization of wrongfully in the room.
I'll sustain that.
Okay. You were there after 9 p.m., correct?
That's just quiet hours. I can't let them in the house.
Okay, sir, please. You were there after 9. Okay. Yeah, okay. You were there after 9 p.m. and you were being quiet?
Yeah, in the video, you can hear me being quiet. I was
No, okay, sir. The washer and dryer weren't on when the video was being recorded, were
Exactly,
they?
so it was quiet.
No, but I'm talking about when you're using the washer and dryer.
Close her out. She had taken them out. She didn't have to come back in and turn the light.
Okay, so what you're saying is the washer and dryer were never on at all?
Objection, Your Honor, that mischaracterized.
That's sustained.
Okay, well, are you saying the washer and dryer were on, ever?
What are you saying? I never even said that. I'm saying at this point, when she left the room, the washer and dryer were off. She had
Okay.
taken the clothes out and she's like, you know what? Now you're out of the room. Now I'm gonna shut the lights out.
Yes, okay.
She kept coming back in.
Okay, but before that, you were using the washer and dryer, correct?
Yes.
Okay.
Yes, I was never denied that.
Okay, and this was after 9 p.m.?
Sure, yes.
Okay. Now, when you and the defendant were finger maneuvering for control of the light switch, was it ever your intent to harm her? Was it ever your intent to intimidate her? Was it ever your intent to put her in threat of some kind of a physical harm? And you did have contact with her hand, correct?
Yeah.
And you were finger maneuvering against her for control of that switch, correct?
Yeah.
Just one minute. For this witness,
All right.
I would ask that has the lease been marked as an exhibit and admitted, Your Honor?
Exhibit 1 is the
Yeah.
second lease.
Yes.
That's been marked and admitted. And I don't know if there was a formal motion to admit exhibit 2.
If there wasn't, I intended to, Your Honor, it would be an oversight on my part. I don't think there's any objection from defense counsel, so exhibit 2 should
Any
also.
objection or
No.
Okay, exhibit 2 is admitted.
Thank you, Your Honor.
Thank you, Judge. I said, Your Honor, I have no
Further question. All right.
further questions.
Any redirect?
No, Your Honor.
All right, very good. Sir, you may step back. Well, I do have one clarification. Sir, the clothes that were taken out of the dryer, which I guess would have been machined to the right, that was the dryer? Well,
I don't remember if that clothes being taken out were wet or not.
pardon?
I don't, if you're asking if the clothes were wet or not.
Well, I'm asking which machine was that?
Like those were my clothes that she was taking out. The dress.
Yes, were they dry or were they wet?
I know those are my clothes.
Okay. I get that. The question becomes, where, was that the dryer they were being taken out of or the washer?
I remember they weren't done. So I remember
Sir.
they're still wet. That's what I remember.
Okay. You recall the video, correct?
Yeah,
Okay. In looking at the video, if you come in the door, there's a machine that's to the left and a machine to the right. Is that a yes?
yes,
She is taking clothes out of the machine to the right. Is that correct?
yes.
Okay. My question to you is that the washer or is that the dryer?
Just when based off of working with washers and dryers, I assume that would be the dryer, but I don't remember exactly. I feel like washers are usually put on top.
Well, I don't.
I don't remember, I'm sorry.
Okay. All right. Okay.
I have no follow-up based on the court's questioning.
Any follow-up based upon my?
No, Your Honor.
You may step down.
Your Honor, may this witness be excused?
Any objection?
No objection, Your Honor.
All right, this witness is excused.
Mr. Loscano, could you hand that back to the court, exhibit 1, please? Oh, I'm sorry. I apologize.
All right, you may step down.
The people rest, Your Honor.
All right, very good.
This is a pivotal moment. The prosecution is officially saying, we've presented enough evidence to support our case. That doesn't mean they've won. It means they believe they've met the threshold required to proceed. The defense, unsurprisingly, sees things differently. And whenever a defense attorney immediately follows with a legal motion, it's a signal that they believe the prosecution's evidence contains critical weaknesses. The courtroom is shifting from fact presentation to legal analysis. The focus now becomes whether those facts, even when viewed favorably to the prosecution, are legally sufficient.
For the defense.
Yes. Your Honor, first of all, I'd like to make a motion for a directed verdict in this matter. I would like to make a motion for a directed verdict. This court knows better than anyone else in the courtroom what the Michigan criminal jury instructions are, which obviously apply to a trier of fact, which is, in this case, Your Honor. There's absolutely nothing here to show anything other than people finger tussling on the control of a light switch. There is no indication here of the defendant trying to harm or threaten. There's no evidence here that she said, look, if you don't leave this room right away, I'm going to kick your blank, blank, blank. There's no bald fist. There's no punch. There's no kick. There's no I've got mace, contrary to what the alleged victim had. There is simply nothing here other than a landlord-tenant issue that is more suited for a civil matter than a criminal matter, Judge. And so even if looking at in the light most favorable to the state, I just don't see how any kind of intent can be induced from two people in a matter of 15 seconds trying to fiddle over a light switch. So that's my first statement, and depending on what the court says, I'll be making an opening statement.
All right. Response.
Your Honor, I do believe that at this point, viewing all the evidence submitted in light most favorable to the people, a reasonable fact finder could conclude that the initial aggressor in the touching was the defendant. And I'll also further state that the defense counsel said there were no evidence of threats. The threat of you're out on the 22nd could be characterized as a threat. That statement about attempting to tell somebody that they can't leave, to leave their house when they're a tenant, that could be characterized as a threat. I'm not saying it is, but I do believe that there's enough evidence here for us to continue going, let the court be the finder of fact in this matter.
Anything else regarding your motion, sir?
No, Your Honor.
All right. With regard to a motion for a directed verdict, in essence, the court does believe that a reasonable fact finder viewing this evidence in light most favorable to the non-moving party, that being the people of the state of Michigan, could conclude that an offense of assault and battery was committed. One thing is that the notion, and it was specifically asked during defense questioning, that the individual, Mr. Toscano, had the right to be where he was. That is clear from the leasing agreement. So he had the right to be where he was. Why, and also specifically, while that may have been the beginning of the assault, there is then the ultimate turning off of the light switch, testimony from Mr. Toscano that he is then put against a wall, certain threats about his residency being said and what was going to happen. He also testified that the defendant's son was in the hallway. So viewing, I'm not saying that would maintain itself, because I'll hear all the testimony, but certainly at this juncture, the court would deny the defendant's motion for a directed verdict. The court does believe that a reasonable fact finder could conclude that an assault and battery did take place.
Judge Simpson's ruling on the directed verdict motion is enormously important. He isn't finding the defendant guilty. What he's saying is that the prosecution has presented enough evidence that a reasonable fact finder could conclude an offense occurred. That's a lower threshold than proof beyond a reasonable doubt, but it's still significant. The defense asked the court to stop the case right here. The judge declined. Why? Because, in his view, the evidence deserved further examination. This ruling keeps the defense's case alive while signaling that the allegations cannot simply be dismissed as a trivial dispute. The courtroom battle is far from over.
Yes, Your Honor. Your Honor, this time we'd like to make an opening statement in
Go
this
ahead.
regard. Your Honor, in this case, we believe the evidence has shown and will continue to show that the defendant is a landlord. And at the time, the alleged victim was a tenant in the house. The evidence will show that a lease was entered into by both parties with a specific statement of quiet hours after 9 p.m. We believe the evidence has shown and will show that the washroom is on the same exact floor of 4 rooms where people live, and that the door was open from the video that the court has seen, and that the noise from the washer and dryer is something that is a direct breach of the lease in terms of quiet hours. We believe evidence has shown and will show that this was not an incident that occurred in terms of complaining witness being in the wash area before 9 o'clock. It was after midnight when this entire matter revolved. We believe the evidence has shown and will show that the defendant was simply trying to exert a lawful prerogative of hers as the landlord to have quiet hours, not only for her enjoyment, but for the enjoyment and security of the other residents of the home, whom she had a responsibility to maintain quiet hours. The evidence has shown and will show, and perhaps, excuse me if I've said this earlier, that the complaining witness knew full well that he had an option. And the evidence will show that he chose deliberately not to exercise the appropriate option in going to an all-night laundromat because he knew that it was improper for him to be there at the laundry room at that time. The evidence will show, Your Honor, that there is a motive that the complaining witness has for bringing forth this false allegation, because what is not caught on the quote unquote videos that the evidence will show has been really tailor made for
We just pause for 1 second. I'm asking if Mr. Loscano can step out in case I do need to recall him in rebuttal.
All right, very good.
Thank you.
Okay, Judge, he's heard part of what I said already, and he was excused already, Judge.
Well, he was excused, but I think during your opening, there may have been something that raised, so
Yes.
he's now been sequestered.
Thank you, Your Honor.
We'll deal with it.
All right. That the evidence, we believe, Your Honor, will show that Mr. Loscano has a motive for bringing forth this false allegation. In his carefully edited videos, there is no video of him touching my client's breasts beforehand. I submit that the evidence will show that that in fact did happen, despite the defendant's, Mr. Loscano's denial. The defendant will testify herself as to the circumstances in the home and what her intent was. So, Your Honor, she will also testify as to contacting the Pittsfield Township Police Department. She will also testify as to mentioning this to a very close friend of hers. So, unfortunately, Officer Olivia Boatwright is not with us, but she was not an officer that was involved in this specific incident, but was someone that the defendant spoke to tangentially afterwards. And in conclusion here, Your Honor, the evidence will show that at no time did the defendant intend any kind of harm, harassment, physical injury, what have you. And the evidence has shown and will show that in terms of any pushing.
Intent is becoming the battlefield of this entire trial. The defense isn't denying that there was tension or even physical interaction. Instead, they're arguing that none of it was driven by an intention to harm, threaten, or violate anyone. That's a crucial distinction because criminal cases don't just examine what happened, they examine why it happened. Was this a landlord trying to enforce household rules in a misguided way? Or was it an intentional act that crossed a legal boundary? Judge Simpson now has 2 competing frameworks, one side describing an escalating assault, the other describing a chaotic misunderstanding fueled by frustration and poor communication. And now, for the first time, the defendant herself is about to take the stand. That means the court won't just hear about her actions, it will hear directly from her perspective.
First of all, the son, John, is not charged with the crime. So, and in terms of some pushing, the evidence has shown that this complaining witness says he doesn't know who pushed him. So how that is proof beyond a reasonable doubt that the defendant pushed him is somewhat stymieing. So, Your Honor, this is what we feel the evidence will show. And at the end of the hearing, Your Honor, we believe there certainly is not enough evidence of proof beyond any reasonable doubt that the defendant is in fact guilty of this matter. And we are ready to call the defendant to the stand at this time.
All right. Ma'am, please come forward and be sworn.
Solemnly swear affirm the testimony you're about to give you the truth, the whole truth, and nothing but the truth, so help you God. Yes. Have a seat and then say and then spell your name.
Speak up.
My name is Anderson.
All right. Go ahead, counsel.
All right.
You may inquire.
Ms. Anderson, you are the defendant in this matter, correct?
Yes.
Do you know a person with the last name, Mr. Lascano?
Yes.
And have you been sitting in the courtroom while he testified? Is he the individual that you entered into a lease agreement with in approximately August of 2024?
Yes.
The court has gotten its possession the lease agreement, and if the court maybe could let you look at that, appreciate it. Now, do you recognize that lease agreement, Ms. Anderson?
Yes.
And is that your signature at the bottom of it as the landlord?
Yes.
Now, is that Mr. Lascano's signature also as the tenant?
Yes.
Now, referring to House Rules item number 3, could you please read for the court, what does that state?
Must maintain quiet hours after night.
Now, in terms of the layout of this is a home that you are renting rooms in?
Yes.
Okay. Now, would you tell the court, in terms of the laundry room, and you've had an opportunity to see the video, correct? That was played? Okay. In terms of the laundry room, are there any other rooms in the vicinity of that laundry room on the same floor? Could you please tell the judge how that layout is?
My bedroom is across the laundry room, and my son's bedroom is next to the laundry room. And Marco's room is, okay, then we have a bathroom, and then Marco's bedroom is further down the hall, and then Paul's bedroom is even further down the hall, and then Raj is in the basement.
Okay. So in terms of these rooms, how many feet would you say separates a laundry room from these 4 rooms?
For my room, it's 2 feet. For my son's room, it's 0 feet, and it's right next to my son. For Marcos's room, it's probably 10 feet.
I see.
From Paul's room, it's probably 15.
Now, can you please tell the judge relative to the laundry room, what role does the proximity of the laundry room to the other rooms on that floor plays a part in must maintain quiet hours after 9 p.m.?
The laundry machine makes a lot of noise, both the washer and the dryer, and I told Marcos and everyone that the washing machines should be used after 9 o'clock because everyone is going to work, studying for interviews. My son is doing interviews for medicine.
The defense is emphasizing something repeatedly. Quiet hours weren't arbitrary. According to this testimony, they existed to protect everyone's routines and responsibilities, work schedules, interviews, sleep. Shared living arrangements can be challenging under the best circumstances, and conflicts over noise aren't uncommon. But here's the question Judge Simpson has to answer. Even if the defendant had legitimate concerns about noise, what actions were legally permissible in addressing those concerns? Rights and responsibilities often collide in shared spaces. Having a valid complaint doesn't automatically justify every response that follows. The line between enforcement and escalation is often where legal trouble begins.
I was going to work, people were, the household, the whole idea of 9 out of 9 o'clock was to maintain quiet.
So what is it on the date and time of this incident that drew your attention to Mr. Lascano in the laundry room?
I was sleeping. It seems like it was about midnight. And then I started hearing this, I didn't know.
Okay, ma'am, you've got to talk up.
Yeah.
Maybe it's
It
me.
was around midnight or after midnight when I heard the laundry machine running and it woke me up.
Okay, now you heard testimony from Mr. Lascano, I believe earlier, saying that at the time the machine, perhaps I'm wrong, but the machine wasn't running at that time or something?
I would object as to mischaracterizing, or at least a clarification. We've got several different timeframes here, some where the machine was running and some where it wasn't. So I'd like
Yeah, why don't we clarify what time frame you're talking?
Okay, at the midnight hour when, okay,
It heard the noise and it woke me up.
okay. So was there anybody else in the washroom doing laundry other than Mr. Lascano when you were woke up?
No.
And this wasn't at 9 o'clock. This is this after midnight.
Objection leading.
Sustained.
Now, the rooms that were there, the noise from the machine, was your testimony was loud enough to wake you up?
Yes.
Was anybody else awoken by the machine?
Was anybody else what, sir?
Awoken by the laundry machines?
I don't know.
Okay.
I woke up.
Okay. Was there a person that was renting by the name of Paul?
Yes.
Okay. To best of your knowledge, was Paul woken up by the machine?
I don't believe so. I don't know. He's 15 feet down, so I didn't see Paul. I don't know if he was woken up or not.
Okay. Okay. So now you've seen the video, and I'd like you to tell the judge, does that video capture everything that happened between you and Mr. Lascano that night? Could you please tell the judge what happened between you and Mr. Lascano before the incident with the light switch and the finger tussling, whatever light switch?
I first turned the machine off and the light off, and I woke up. And I went back to bed, hoping it was the end. And then maybe 5 minutes later, I heard the machine again, the light was on, so I went out of my room. And when I was going into the room, Mr. Lascano grabbed me.
When you say he grabbed you, what part of your body did he grab you on?
He grabbed my clothes.
Would like a Kleenex or something, ma'am? I think there's a box, ma'am. I think there's a box of Kleenexes there. Okay. So
Did she need time to compose herself?
do you need a moment, Ms. Anderson? Okay, because you have to compose yourself so the judge can hear you. Okay. So after this incident happened, you say he touched your breast. What did you do? Okay, okay, ma'am, if we need to take a recess, we'll do that. But the judge has got to be able to hear clearly what you're saying.
I was in shock. I froze.
The emotional dynamics of this case become even more complicated here. The defendant is describing her own experience as one involving fear, shock, and paralysis. If believed, that testimony could significantly alter how Judge Simpson interprets subsequent events. But credibility assessments are rarely straightforward. The court must consider consistency, corroboration, timing, and demeanor. Trauma responses vary widely from person to person, and judges are often tasked with evaluating deeply human experiences through legal standards. The prosecution will undoubtedly challenge aspects of this narrative. The defense, meanwhile, is asking the court to recognize that emotional responses don't always fit neat expectations.
Okay, what happened after that?
I remember reaching over, turning off the light, and hoping he would just leave and go back to his room. And I went back to my room, and I thought it was the end. I was processing.
Okay. So did there ever come a time when you and he had some kind of a finger contact about the light switch?
Yes,
Okay, just
Yeah.
that's a yes or no question, yes or no answer. Did there come a time when that happened?
yes.
Okay, could you please tell the judge circumstances what led to that happening?
After several times, he would go in and start the laundry machine, turn the light on. It seems like there was a couple of times, I wasn't counting. I would go in and turn, and so we back and forth with the light switch, that's what I remember. I don't remember how many times I turned it off and he turned it on. I don't remember how many times that, but it just was constant back and forth, and I was hoping it would just end.
Now, but was there a time when he was finger maneuvering with you for control of the switch?
Yes, he was touching, I mean, I was turning it off and he was turning it on, and it was back and forth with us. And I don't remember how many times, but it seemed like, it almost seemed like a game to him. And I was just wanting to go to sleep. Just ended. I didn't want to escalate.
Okay, now, when you turned the light switch off, okay? All right? Okay, did his hand come in contact with your hand trying to turn the light switch on?
Yes.
Okay. So I want to be sure that this is clear. He touched, at some point in time, touched your hand trying to turn the light switch on. Did you consent and voluntarily say, please touch my hand to turn the light switch on? Okay. Was that touching of your hand to turn the light switch on, was that against your will?
Yes.
Okay. Was that without your consent?
Yes.
Okay. Now, you heard testimony where the complaining witness said someone pushed him, the light was out and somebody pushed him like maybe into a wall or something. Did you hear that testimony?
Yes.
Okay, at any time, did you push Mr. Lascano into a wall?
No, sir.
Okay.
He's bigger than me. I remember.
Okay. Now, in terms of the touching of your breast, at some subsequent point in time, did you have an opportunity to report that to the police?
Yeah, but
Okay, ma'am, just yes or no? Okay. Do you remember the name of the police agency that you have reported that to?
Ms. Boatwright.
Okay, would that be the Pittsfield Township Police?
Yes.
Okay, did you see Miss Officer Boatwright in person?
Yes, sir.
And did you report this incident to her?
Yes, sir.
Okay. Now, in terms of weaponry, at any time, did you have any mace on you, Miss Anderson?
No, I don't have weapons in my house.
Okay. At any time, did you threaten Mr. Lascano with any kind of a weapon?
No, I don't have any weapons. I don't believe in weapons.
Okay, ma'am, okay. At any time, were you threatened by Mr. Lascano with mace?
Yes, sir.
The introduction of mace changes the emotional landscape once again. According to the defendant's testimony, hearing that someone possessed mace intensified the sense of danger. The prosecution may point out that the complainant testified about mentioning it only after allegedly being pushed against a wall. The defense, however, is emphasizing how threatening that statement could sound from the defendant's perspective. This illustrates a recurring theme in the case. Identical facts can generate entirely different emotional realities. Fear isn't always symmetrical. What one person experiences as self-protection, another may interpret as intimidation. Question for you. Do you think intent matters more than impact in situations like this? Or should courts focus primarily on what actually occurred, regardless of motivation?
Okay, could you please tell the judge what happened then?
It's that once my son woke up from the back and forth, came out, then Mr. Lozano, he said, hey, I got mace, so back off. You know, it was, he said that, and I'm like,
Okay, okay. But you never had any mace? Okay. Now, after this incident happened with him touching your breast, do you know a person by the name of Ivory Clinton?
yes, sir.
And who is Ivory Clinton?
He's my dear friend. I've known him for over 20 years, and he's like family.
Okay.
I don't have any parents.
Okay, okay. Did you report this incident in terms of the breast situation with Mr. Clinton?
Yes, I told him that.
And I'm sorry, when?
Yes, sir. Yes, sir.
And when did you tell him that?
The morning, the next morning.
Okay, and isn't it true Mr. Clinton was subpoenaed to be here this morning?
He's outside.
Okay, all right. Ms. Anderson, why did you wait and didn't report this incident with your breast to the police right away?
I didn't trust police. They were strangers, and if you knew my backstory, I suffered sexual abuse and racial abuse growing up as a child. My own mother threw me away because I was half black.
Okay.
And I had
Okay, so what is it that made you decide to report the matter to the police when you did?
time to process it.
All right.
And I didn't trust white authority because in my childhood, when I reported abuse, no one ever did anything.
Okay, okay, all right. So, Ms. Anderson, in this situation, and this is coming to an end here, ma'am, was it ever your intent to harm or threaten or violate Mr. Lozano in any way? Okay. Tell the judge what was your intent in this entire situation.
I wanted to just have quiet peace in the house and make sure that all the tenants, including myself, were safe. That's what I wanted. I was hoping that he would just stop.
Okay, all right.
This testimony captures the defense's central theme in one sentence. The defendant wanted peace, not conflict. If Judge Simpson accepts that premise, the defense gains significant traction. If he believes the defendant's actions exceeded reasonable efforts to maintain household order, the prosecution's theory becomes stronger. Intent, reasonableness, credibility. Those three concepts continue surfacing again and again. The courtroom isn't simply reconstructing events, it's trying to understand the motivations behind them. And as cross-examination approaches, those motivations are about to face intense scrutiny.
Ms. Anderson, I have no other questions. Prosecutor may have some questions for you.
Cross-examination.
Thank you, Your Honor.
Ms. Anderson, what day did this happen?
It was in November.
November 16th sound right?
Yeah.
You were sleeping and it was around midnight when you were woken up by the laundry machine? And you said it makes a lot of noise, right? And you said your son was woken up by all the back and forth between you and Mr. Lozano, right? But Mr. Lozano and you, when you were in having your back and forth in the laundry room, that was after the machines were shut off, right?
I believe I had shut the machine off and then shut it back on. So we were tussling with the light switch. So I believe, I don't know how it was on.
So you're not sure what woke your son up, right?
I am not 100% sure.
Okay. And your son's room is closer to the laundry room than yours is, correct? And you were living at this house at the time?
Yeah, on again, off again.
On again, off again? And you saw People's Exhibit 1, correct? The video? I'm sorry, People's 2, excuse me. I misspoke. The video we looked at earlier?
Yes.
And you said that the victim was the only person in the laundry room, right?
Yes.
And you said that you turned off the machine and the light, and then the victim grabbed your breast. And-
When I walked in, he caught me by surprise, and that's when he grabbed my breast, when I first walked in, because that was the second time I had walked in and shut it off when he wasn't there. First time I walked in, he was already in his room, and I shut it off and turned off the light. Then I went back to bed, thought it was okay. Then about 5 minutes later, I heard the machine again. And so I was gonna just go in and turn it off, turn the light off again. And when I walked in, he grabbed my breast and I froze.
Everything changes with this allegation. Until now, Judge Simpson has been listening to a case centered around laundry, quiet hours, light switches, and competing interpretations of physical contact. But the defense is now presenting something entirely different, an allegation that the defendant experienced unwanted sexual touching moments before the confrontation captured on video. Here's the challenge. There is no footage of this specific claim. The court is left with testimony alone. That doesn't automatically make it false, nor does it automatically make it true. It simply means credibility becomes absolutely critical. The prosecution will likely question timing, consistency, and why this information emerged in the way it did. The defense, on the other hand, is presenting it as the emotional catalyst behind everything that followed. Judge Simpson now has to weigh not just facts, but human reactions. Because if this allegation is believed, the emotional context of the entire case changes dramatically.
And he grabbed your breast because he was standing at the doorway?
He was in the laundry room.
He was in the laundry room. And then grabbed your breast. And you froze.
I
I'm just asking, you said on direct you froze. I want to make sure I understand.
was just, it seems like all of my childhood stuff started coming out and I just froze.
But you turned off the machine and turned off the light and went back to your room, right?
I don't.
You don't remember. Okay,
I
fair.
And, you know, I know I shut off the light. I don't remember if I shut off, I don't think I shut off the laundry machine. I know I shut off the light and went back to my room and I hope, yeah, I was just in shock. I did.
And from the first time that you went in and shut off the machines and the lights till when we see the video we looked at today, that all happened within just a few minutes, right?
I mean, yeah, I mean, there was probably 5 minutes. There was he turned the machine on. I turned the machine, he went back to his room. I turned the machine off. I went back to my room. And then the second time when I went back in there, I thought I was just going to shut the machine and light off. And he was there and he grabbed.
And you would agree with me, though, that from the first time that you went in there till the end of the video we watched, that was just a few minutes, right? No, not sure about time. Wasn't counting. So when you went back in again to turn the machine off, that's when you started taking the clothes out in the video?
Yeah, I think I started taking the clothes out. I mean, he had the video, but yeah, I think I started the third time when he turned it on and I went back in. I think I started taking the clothes out.
Okay, so I'm gonna ask you a really, really simple question. Well, the video that we watched, that's the third time that you went in there to shut off the lights and turn off the machines?
These are the third one.
After, that video happens after he had grabbed your breast, right?
No, he grabbed my breast in the beginning.
So the video we watched,
Before he did any video, that happened.
so let me ask the question, I think we're saying the same thing, so just listen really closely. The video we watched today in court happened after he grabbed your breast.
Correct.
Okay. And in fact, you went back and forth into that room more than one time on that video that we watched, right?
I think the video showed the lights going on and off a couple of times.
And before the lights go on and off, it shows you going back and forth for some of the laundry, right?
I think I did at least one time.
Just one time. And you told him that he had to leave your house, didn't you?
I said I was, you know, I was gonna give him an eviction notice.
Is that what you said?
Well, that's what I meant.
But what did you say? You said you need to leave my house, right?
Well, I mean, if he doesn't want to abide by the rules of quiet hours after 9, I thought maybe it would be better if he would leave my house.
Man, my question's very simple. But didn't you tell him to get out of your house?
I think I may have, yes.
You may have. And didn't you tell him he was going to be out on the 22nd?
I think he had paid, it was a month lease, and I think he had paid through the 27th. I think.
No, but focus. Didn't you tell him he was going to be out on the 22nd and maybe 27th? It's hard to hear, but you told him that, right?
I was, what I meant was the date that he had paid through.
So you told him that he had to be out on the 22nd or the 27th, right?
I don't remember the date.
Okay. You would agree with me because it's captured on the video that the first time we see you turn the lights off in that video, Marcos's hand is nowhere near that switch, right?
Yeah, but
And then you would agree with me.
Excuse me, can she?
She said, yeah.
She answered the question. So go ahead, Ms. Blondie.
And then you would agree that he turns the lights back on, right?
I don't remember every single step. You're asking me to recall everything. I don't remember. I wasn't taking video. I just remember some key points.
You've had a chance to review that video before today? Is that a yes?
Yes.
Sorry, same thing. Like we just have to have the recording.
But the video didn't capture everything. It didn't capture before and it didn't capture after.
Which is the nature of all videos, right?
Yeah, but it didn't capture me supposedly pushing him or anything like that. It just stopped.
So ma'am, my question is, do you recall that he turns the light back on after you turn it off?
Yes.
And you turn it off again,
Yes.
and he turned it on again?
I'm trying, you're asking, I don't remember everything.
Okay.
You're asking me to say something, I don't remember everything. I remember we were going on and off and on and on. That's all I remember.
And at some point, he had his hand on the light switch holding it on, right?
Yeah, just like I had before that.
And you pulled his fingers away to turn it off?
Yes, but yes. And he had touched me before.
Oh, ma'am, I didn't ask you any questions about that. My question was just about the light switch. Do you recall appearing for court here on February the 5th, 2025?
Yeah.
And do you recall that's the date that this case got set for final settlement conference? Does that sound about right? And is that in fact the day that you went to Pittsfield Township Police Department to talk to Officer Boatwright about your breast being touched? And isn't it true that you told Officer Boatwright that you were discussing the case with your attorney and decided that the updated version of events needed to be reported?
I mentioned it to the lady at the counter and she said, I told her and she said I should go report it.
So on February 2nd of 25 is when you went to Pittsfield and you were able to chat with Officer Olivia Boatwright, correct?
At that point, I had the courage.
What lady at what counter?
And Your Honor, the court asked a question which I was going to ask. I don't understand what is this all about? Who is the lady? Where?
I'm assuming it's about the date that the report, but I'm trying to figure out what lady at what counter.
here in the court, I was going there asking her why, how I could include some other information, and because no one ever called me, and she told me to go to the Pittsfield Township Police and report it there, and I said.
It was one of the court clerks that told you that?
Yes, I was telling her that no one called me I said I had some more information.
Okay, all right.
She told me to go.
You answered my question. Go ahead, Ms. London.
And that was the date that you were able to go to Pittsfield Police Department and make that report?
Yeah, I had.
It's just a yes or no. So that's the day you went, correct? On February 2nd, 2025?
February 2nd or February 5th?
I said this, I meant the 5th. I apologize, Your Honor. I misspoke. I read the 2. I meant February the 5th. Didn't you in fact tell the police officers though, that that your breast was grabbed when you were removing the clothing from the dryer?
Well, excuse me, Your Honor. She's saying tell the police officers. She spoke to one police officer, Officer Boatwright. Who are these officers?
I don't know.
Well, hold on. At what point are you talking about?
I'll rephrase.
All right.
When you went to Pittsfield Township Police Department on February the 5th, and you spoke with Officer Boatwright, isn't it true you told her that this happened while you were removing the clothing from the dryer, this being the touching of your breast?
No,
That's not true. So if that's in a police report or if that's captured on Officer Boatwright's body camera, that's not true?
yeah, I told her I walked in and she grabbed my dress.
All right. So if we are able to get Officer Boatwright here or review her body camera and we find out that that was what you told her, that would not be true.
I told her exactly what happened.
So if it's different than what you're saying now, which one's true?
Well, Your Honor, first of all, she's asking
Let's
speculative.
cross-examination, Mr. Mack. I'm gonna let the questions go. Go ahead, Ms. London.
Please answer the question, ma'am. My question was, if we review Officer Boatwright's body camera, or we have her testify, and she testifies or her body camera indicates that you told her that your breast was grabbed while you were removing the clothing, right? Would that be true?
I did not tell her I was removing. I told her we were arguing over the laundry machine.
Okay, and if the body camera or the testimony from the officer indicates that you said it happened while you were removing the clothing, that would be different than what you said today, right?
I did not tell her that, so she would be lying.
She would be lying,
Yes.
and her body camera recording would be lying if it captures you saying that.
I did not say that. You're putting words in my mouth.
I'm just asking a question. If those two things happen to be, okay.
Ma'am, are you gonna answer the question, please?
I told her.
So if Officer Boatwright says something different, she's lying.
Yes.
Your Honor,
And-
I was asking-
All right. Well, not really, but okay, we have the answer.
And if the body camera captures you saying that it happened while the clothes are being removed from the dryer,
No. Why are you? I didn't say that.
All right.
may I have a moment, Your Honor?
Yeah.
Nothing further, Your Honor.
Ma'am, what were the hours that constituted the quiet hours?
9 p.m.,
Until when?
9 a.m.
The agreement doesn't say that though, is that
Well-
right?
waking hours.
Well, ma'am, the agreement doesn't say that, correct?
Correct.
All right. Because I'm a bit confused about the whole arrangement and disagreement, but is this property registered for rental with Pittsfield Township?
At the time, it wasn't because I was an owner occupant, and I was told when you're an owner occupant,
Okay, so that's a no?
No,
All right. Um,
because I even asked.
what? Why was it important to you that the light switch be turned off?
Because I was hoping that we would stop doing the laundry, light switch off and the laundry machine off. So when I went in there, I turned the laundry machine off and turned the light switch on.
Okay, but when you went back in, you also turned the light switch off, right?
I mean, I'm paying utilities, so I,
Well, no, you're not, according to, look at your lease agreement. Doesn't his rent include utilities?
yes.
So he's paying utilities.
Yeah, but part of the rules that I put on the refrigerator is everyone should try to conserve energy and keeping them.
Ma'am, why were you turning off the light?
Because it was midnight. And I thought it should be shut off and everyone should be asleep.
But that agreement doesn't say that though, does it?
I thought it was assumed at 9 p.m. quiet hours. That's what I explained to him when he signed the lease, that it was to be quiet hours.
Ma'am, would he be violating the quiet hours if he had gone into that room, did no laundry, but just stood there with the light on?
No,
So what was the purpose in turning the light off?
just that have him maybe go to just stop doing the laundry.
Okay. So at some point, and you saw the video, you're removing his clothing from the machines, correct?
Yes,
Was that from the dryer?
I believe it was from the washer.
So the clothes were wet?
Yes.
Where did you take those clothes?
To the room.
And when you took them to his room, what did you do with them?
I think there was a laundry basket or something, or maybe I put him on the floor in his room.
Pardon?
I think I put him in his room. I think I recall putting him on the floor in his room. Or maybe there's a laundry basket right there by the door.
So you recall the clothes being wet and you put them on the floor?
Yeah, or in a laundry basket. I can't recall if it was a floor or the laundry basket.
Okay. When you walk into that room, is the dryer to the left or to the right of the machines?
Oh, you know what? Now that you're saying that, I actually pulled them out of the dryer because.
Is the dryer to the left or to the right when you walk in the room?
When we walk in, dryer's to the right, so I was pulling out of the dryer, washers to the left.
Okay,
So they were in the dryer and not quite dry.
all right. So what was your purpose in removing the clothing from the dryer?
To have him, observe quiet hours and just not do laundry at midnight.
Okay, so let me ask you this. Once you had accomplished that, had you not then at that point restored, I guess, this quiet hours?
I kept this whole situation when the laundry was, I took the laundry out. Quiet hours were restored, but then when you would go back, if I if I went back in, it was because the water machine, the washer was being used. I don't recall exact details, but it was just either one machine or the other was being used. I don't recall, but I just wanted to go to bed and have it in. And
So are you claiming they were closing the washer now?
I think there were.
Then why didn't you remove those clothes?
I don't know. I just was trying to get him to stop using the laundry. I wasn't taking notes. I wasn't.
I'm not asking if you're taking notes. I'm saying, why didn't you? You're now saying that there were clothes in the washer.
There were clothes in the washer and in the dryer.
So if it were trying to get him to stop, why did you only remove the clothes from the dryer?
The washing machine was, I believe, was off, and I was just trying to get him to stop. I wasn't thinking, oh, remove him from the washer and the dryer.
Ma'am, I'm trying to figure out why you did what you did.
I was just trying to get him to stop, sir. I was just trying to.
And in doing that, I'm also trying to figure out why you removed the clothing from the dryer.
Just trying to get him to stop, sir.
Okay. So once though you had removed the clothing from the dryer, put them in his room, either in a basket or on the floor. At that point, there was no longer noise coming from that room, correct? And when you came back into the room after you removed the items from on top of the dryer and went down the hallway, you came back into the room, right?
I think I tried to turn the light off.
Okay, but if he had turned the washer on, why would you turn the light off?
I thought it was time for everyone to go to bed. I just wanted that, normally what I would do is turn the washer off for,
Did
wash.
you turn the washer off?
I believe, I don't want to misstate things, but I believe both the washer and dryer were on at some point, and I don't know what order I turned them off.
Ma'am, at some point when you removed his clothing, did you want to see the video? I'm not trying to trick you. I'm just trying to yes, can we put
Yes, Your Honor.
put exhibit back up?
I think it's two.
Could we play the whole video? Would that be okay?
I don't want to.
I don't care if we play the whole video. That's fine. We can play the whole video.
It's only about 2 minutes long. Judge, I had to interrupt. Can I just have a bathroom break just for a moment? Whenever it's appropriate.
Okay, yes, just momentarily. I don't have many questions, but I'm just trying to figure something out here.
You're touching it close enough. That's not okay. You can't touch my property. You're not allowed to touch my property. No. You can't touch my property.
Oh, I'm trying to sleep.
You can't touch my property. Please tell me stop that. All the time you're gone.
Those are my towels, the last set of towels were mine.
Okay.
Can you please not touch me? Can you please stop touching me?
Hear the
Can you please stop touching me? Okay. No, okay, let me. What the hell? No, you can't do that. How can you do that? But have you sent me an eviction notice?
You're out on one side.
No, you can't do that. You know you can't do that. You have no legal right to do that. If you want to try doing that, let's go to court. Please stop touching me. Please stop, you're grabbing my hand. Okay, she's not grabbing me. Look, I'm gonna keep this light off, right?
Okay, ma'am, you've seen that, you just saw the video. After you just now, not through a question, but you said the items that were on the top were your items.
Yeah. Did you hear that little bell?
Okay, ma'am, yes, I heard the little bell that told me that was the dryer. So, when you took the items that you now say are yours off and are leaving the room, at that point, the washer's not running, is it?
No, but I thought I heard the bell.
Well, ma'am,
Yeah.
the washer's not running, right? And at the point at which the dryer door shuts, and that's when you hear the little bells,
Right.
and you grab the stuff ultimately off the top, the dryer's not running either, is it?
Correct.
Okay, so at that point, safely we can assume there's no noise coming from either of those machines.
Correct.
This seemingly simple answer could carry enormous weight. The defendant acknowledges that, at this point, neither the washer nor dryer was actively making noise. That's important because the defense has consistently framed this incident as an effort to enforce quiet hours. But if the machines weren't running anymore, Judge Simpson may ask a logical question. What exactly was the purpose of continuing the interaction? That doesn't automatically favor the prosecution. The defense may argue that restoring nighttime conditions, including darkness, remain the objective. Still, this testimony introduces nuance. If the original justification was eliminating noise, and the noise had already stopped, the court now has to examine whether the later conduct served a different purpose altogether. Sometimes trials turn not on dramatic revelations, but on small distinctions like this one.
When you walk out of the room, then what is your purpose in turning out the light?
I was just thinking that if I turned on the light, he would leave the room and go back to his room. And not use the washer or the dryer.
But to be clear, the turning off of the light had nothing to do with the quiet hour. Is that correct?
Well, in my opinion, it did. But,
Why?
I mean, I know you may, I just thought the lights out, you know, it's quiet hours. In fact, the light from the living room actually shows through my door.
Yeah, but that's not a violation of anything, is it?
I can't personally sleep with light. I have to have darkness. So, I mean, maybe it's not a violation, but I was just hoping to stop him from doing one.
All right,
And
okay. I think it might be a good point to take a recess, and then you can put it back up, and then you can re-question. Court's gonna stay in recess. Court does recall the case of the People versus Lori Anderson.
Pass along to the people.
Your Honor, Hugo J. McIntyre with on behalf of Ms. Anderson, who is in the courtroom today.
All right,
Your Honor, it is my understanding the defendant has decided to plead to assault and battery, and in exchange will receive consideration and a prosecutor's deferred sentence, which all wants a probation.
And just like that, the trial takes a stunning turn. After hours of testimony, cross-examination, objections, and competing narratives, the defendant elects to resolve the case through a plea agreement. This is one of the biggest misconceptions about courtroom proceedings. Not every case reaches a verdict. Sometimes, after hearing the evidence unfold in real time, parties reassess risk. For the defense, plea agreements can offer certainty. For prosecutors, they can secure accountability without further litigation. Judge Simpson now shifts from fact finder to ensuring that any plea entered is knowing, voluntary, and legally appropriate. The courtroom drama may be approaching its conclusion, but the legal process isn't over yet.
Is that a correct statement?
Yes, Your Honor, we have proffered an advisory rights form signed duly to the court, Your Honor.
All right. Ms. Anderson, could you step to the podium, please? She had been sworn as a witness, but could I have her sworn?
You were swearing. You solemnly swear affirm the testimony you're about to give be the truth, the whole truth, and nothing.
Yes.
Go ahead and state and spell your name again.
Lori Anderson.
All right. And Ms. Anderson, just so that we're clear, we were in the middle of a bench trial in this case. The court had not made its finding. You've had an opportunity to speak with your attorney and you wish to now plead guilty to this charge.
Yes.
All right. The offense of assault and/or assault and battery is a misdemeanor, punishable by up to 93 days in jail and a $500 fine plus court cost. There is a sentence agreement that the parties have, which the court, after probation, the court would, however, indicate that I don't see a reason why this, I'm not making an agreement, but I don't see a reason why this court would not follow that. Okay. Given what I've heard in this case. You understand that, Ms. Anderson?
Yes.
And understanding the maximum penalties on this, how do you wish to plead to this case?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
All right. You signed an advice of rights form today. Is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. You'll see a copy on the podium there and it's highlighted. Those are your rights which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily,
Yes.
of your own free will,
Yes.
and also because you believe that you're guilty of this offense?
Yes.
All right. Just get the date right. I think it was November 16th, 2024, at the location of, it's not on that one, of Chandy Court, Pittsfield Township, Washtenaw County, State of Michigan. On that date, there was, I'm going to just ask you to acknowledge this, there was a dispute regarding the use of a laundry room. Is that correct, ma'am?
Yes, sir.
And during the course of that dispute, there was then an issue regarding the turning off of the light, correct?
Yes, sir.
Between you and the other individual. And at some point during the turning on and off of the light, there were no longer just fingers coming into contact with each other. At some point, you grabbed the hand and or arm of the other individual. Is that correct?
Yes, sir.
All right. And when you did that intentionally.
Yes, sir.
And Ms. Anderson, you would agree that given all of the circumstances at that time, that the grabbing of that would reasonably or potentially place somebody in fear. If they had some fear at that point, you would agree that that fear of some harm would be reasonable.
Yes, sir.
All right. Counsel, have I complied with the court rule and would it be proper to, well, I won't ask you that. Miss, I do also have to advise you before I get to that, Miss Anderson, that if you commit misconduct as defined by the Michigan court rules from the date I accept your plea to the time of sentencing, that any sentence evaluation or agreement this court would no longer be bound by. You understand that?
Yes, sir.
You also understand that you would not then also be entitled to withdraw your plea. You understand that?
Yes, sir.
All right. Is council aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Defense not aware of any, Judge.
All right. And now, have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Judge.
The court will accept the defendant's plea of guilty to this charge. Today is the what?
14.
I've been in a room with Hugo Mack. It seems like the 20th. No, I'm sorry.
Oh, no, Judge.
I just thought I'd throw that out
Oh,
there.
of course, why not?
All right. Court having accepted defendant's plea, defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
August 13th, 2025 at 9 a.m.
August 13th, 2025, 9 a.m. Bond with its conditions will continue. All right. So ma'am, I would only suggest that as you exit the building, probation will be on your left-hand side down the hallway. You may want to stop in there and at least start the process. All right. Does that date work for you, mister? I see you looking at it.
Yeah.
One word. After all the testimony, after the videos, after the arguments, after the emotional allegations, everything narrows down to one word: guilty. Not because Judge Simpson announced a verdict, but because the defendant chose to accept responsibility under the terms of a negotiated resolution. For viewers, this ending may feel unexpected. Trials often build toward dramatic judicial declarations. Instead, this case concludes through a decision made by the defendant herself. But even without a verdict, the lessons remain powerful. Small disputes can escalate rapidly. Emotions can complicate memory. Context matters. Intent matters. And ultimately, the justice system exists to navigate precisely these kinds of complicated human conflicts.